So I'm going to let Mark take the floor and explain to you what the role of probation is in the probate and family court, and what services the probation department provides to attorneys and families who are involved in probate court cases. So, welcome, Mark.
Thank you. How many people have been in the probate court? Doing lawyer of the day or visiting, or whoever's done lawyer of the day, thank you very much. Great project. Started about 15 years ago in our Salem office, which is home base, and it makes our job a lot easier, even though the litigants that come in assume that you are their lawyer, and they learn that you're trying to assist and give them information. It helps a lot. The screening process helps a lot. We have people that have come in that have been multimillionaires, think they can do it on their own, want to come in, try to get in to see the lawyer of the day, and then they get screened out. But what you do or what you will do once you graduate will assist us. And I guess I might as well just say it right out. Anytime any one of you want to come in and visit and see what we do on a day-to-day basis, you can do it through Jeannie, or just come in, make an appointment, and you can stand behind our counter and see what we do. Unfortunately, you won't be able to go in to see the dispute intervention service that we provide to the court, but at least you can see how we deal with the people on a day-to-day basis and what's happening. Probate court has a probation department just like all the other divisions of the trial court. Being the only civil court, non-criminal, our role is a little different. Our major function is dispute intervention. So on a day-to-day basis, cases that come into court have to check into the courtroom for whatever the issue might be. And the clerk in the courtroom will then screen the case to see whether or not they will send it to the probation department so that we might be able to resolve the issues. If we can resolve the issues, it's put into writing, it's made into a stipulation, it becomes a court order. Whether it's a temporary order, whether it's a contempt, whether it's a modification, whether it's a paternity case, no matter what. If we cannot resolve the issues, we do make a written recommendation to the court. Everybody knows what it is, litigants, attorneys, and it'll go to the courtroom for a full hearing. That is our primary function. We also do investigative work, contested issue. After hearing, the judge decides that he or she might want further information, ask my department then to go out and investigate a specific issue. A lot of the probate courts in Massachusetts have stopped doing investigations only because of the lack of personnel. We also do monitoring of cases where people are ordered to do seek work program, go out and get a job in order to pay child support. We monitor drug and alcohol abuse cases. We send people out to have testing done, whether it's drug and alcohol screening or the all-new hair follicle test. And we also provide information to the court when it comes to gathering facts from other states, out-of-state criminal record checks, background checks. And our final job is this. We have to do community service, mandated, so many hours every semester. And we go out to schools, to civic groups, and to anywhere we're requested. I will send probation officers out to perform their civic obligation. So instead of me just talking throughout the next hour or so, if anybody has any questions as I'm speaking, raise your hand. We might as well try to answer the question.
What are the standards by which you determine whether something is fit for the judge or for your group in particular?
In what particular instance?
Well, you mentioned earlier that there's a screening that goes on, and it's decided by the clerk, I think you said?
Yep.
Whether the judge will hear it or whether it goes to your department. What are the standards by which the clerk will, how is he going to determine that?
Okay, case is brought into court, divorce case, or paternity case. Somebody marks up motions for temporary orders. And the issues are custody of the children, visitation rights, and child support. There's never only one issue. They lump everything together. Whether it's the litigants who are pro se in our Lawrence session, 85% of all the cases that come into court, at least one party's pro se, 85%. In our Salem office, which is home base, 65%. In my Newburyport session, probably 40%. So we covered 3 sessions. So the clerk will see that the contested issue might be custody or visitation. Instead of wasting an hour and a half and taking time away from all the other cases, refer the case to the probation department so that we can try to take the attorneys and the parties in, see what the issues really are, come up with some resolution if we can. They'll satisfy the parties, that'll fit the state law, and also become, part of an agreement. So the screening process really done by the clerk on a day-to-day basis. We know the way they write cases and refer them to us as to what they're looking for us to try to do. Obviously, there are some cases that are never going to settle. There are some attorneys, I shouldn't say this, that never want to settle. So in my office, I've been chief for the last 14 years. I've been in the probation service for 30, coming up this November. We do have attorneys on a little board that's in our heads who really give everybody a pain in the backside. And guess what? They never get anywhere. So as soon as we see them coming, the clerk knows he screened it in. It doesn't work. It doesn't work for the attorney. It doesn't work for their client because we control the flow. So you're supposed to check into the courtroom at 8, 8:30. You could be referred to my department at 8:30, 8:45. You're supposed to have all your paperwork ready, including financial statements and anything else you need to submit. But guess what? I call the case when I want to call the case. So if you're going to be a pain in my behind, even though you're there at 8:30, I might call you at 2, 3, 4, or I might say, guess what? Remark it. We're not calling you today. We go. You're not on that group yet.
It's good to know.
Actually, I just have a quick question in regards to the Law Advocacy program. I'm just trying to recall that the people who avail of that service, were they required to sign like a waiver prior to see the attorney so that they can't state a claim that there was a client-attorney relationship had been developed, and as a result maybe like sued for malpractice or for as a result of
The major thing is financial to see whether you do qualify. But
having qualified.
if you qualify, then to me, I don't really get involved in that process because it's done in the clerk's office, but I know that there is a screening.
You've actually done the screening. That's what you did when you went out and interviewed people. You did you took the intake, you interviewed them briefly, and then you did an income analysis based on what their income was, and the number in the household, and then you used the little table down below to determine whether or not they were income eligible or not. If you're asking whether or not there have been problems with people suing attorneys that volunteered in the program for bad advice, not to my knowledge. It is, I'd have to say though, when you do see a client in Lawyer for the Day, they are I think at some level, you know, their conversation with you is a privileged conversation, subject, of course, to the fact that they know that you're a student there. They've been informed of that, but you also have to, nothing that the client comes in and says is you're really under my supervision. Can you go and talk about after you leave? You understand that? But in general, I haven't really heard of any stories where someone has come back and complained that they got terrible advice. And if you think of it, we don't have a whole lot of time to spend with people in the first instance. You know what I'm saying? But I do think that, you know, rules of confidentiality and that do apply in the context of a consultation. It's just that you make it plain, and there is a disclaimer on the form that says, the attorney for the day is a volunteer today to assist you in the selection and preparation of forms, but is not representing you. You know, so, and we try to make that clear. We're just trying to move them from one point in their case to the next, but that we will not be filing an appearance or representing them in their case.
Did I miss somebody? A question?
I was just going to ask you what your background is.
Merrimack College grad, little beyond that. We're required to take minimum of 15 hours of credits every semester. Credits are offered by the Office of the Commissioner of Probation, who we work for. We do not work for the trial court anymore as of 2 years ago. We now come under the Office of the Commissioner of Probation. So in the trial court itself, the legislature has made a determination that there are 3 managers in every specific court. So we're talking about probate court, superior court, district court, juvenile court. There are 3 managers: the first judge, the clerk of that court, and the chief probation officer. We're required to meet quarterly. We are the decision makers in that court. So not one person can make a decision without all of us coming to a consensus. The judge doesn't tell me what to do. I don't tell the clerk what to do. It used to be that way. That's all been dissolved as of about 3 or 4 years ago. So we're constantly being trained because we could not do our job unless we knew what the law was. How could we make a recommendation to try to resolve issues if we didn't know what the law was? So we're constantly being trained. We have our staff meetings once a month internally. Any issues that do come up, changes of the law, changes of the federal statutes, child support issues, we do. Sometimes I bring in people. We have a major issue right now going on, especially in my Salem office, home base. Cases where a lot of illegal aliens, all of a sudden, they have an action pending before the court. What do? How do we proceed? Somebody makes a claim that somebody's illegal. What is our obligation as an officer of the court, and who do we actually call? So we're doing training right now, and I have it set up, I think, for next month that we're going to get somebody in from INS to give us a little background. A year ago, when they changed the sex offender registry, big problem. We're a civil court. But the requirement is that when you come into court, I didn't bring one unfortunately, I'm going to give you a blue sheet. It's our intake form. It's requesting information on your client. Name, address, city, state, date of birth, place of birth, social security number, your client's parents' names, deceased or not, whether they're employed or not, where, whether they receive any other benefits, what type of health insurance, your name is their attorney representing them, the number of children, any outside agencies involved, DSS, DOR. If you're pro se, same form. Pro se, we give you an appearance form. Appearance form says I'm representing myself. We do not fill out those forms. I'm going to revert back to the sex offender registry. So if we're gonna do a criminal record check, carry now, instead of Corey. Carry is court activity information. Corey, criminal offender, all right? So there's a little play on words that they changed. So you're filling out the form, you give me the information, all of a sudden it pops up that you're a sex offender. Because Carrie prints pages, and they're labeled on top. If you had any juvenile case, it prints up and it says juvenile. If you have any adult case, it says adult. If you had any restraining order issues, it says civil. If you were a convicted sex offender, it says convicted sex offender. Comes up convicted sex offender, the first thing we need to do is to verify your current address by statute. Why? Anybody know why?
Aren't you supposed to check you with probation?
Supposed to register in the city or town. There was a Lowell case that went into Uber, just got heard last month. It was out of the probate court in Middlesex. And the gentleman went to Uber and he killed a lady and their daughter. Was not a registration situation because he wasn't living there, he was moving back. So since you're the litigant or you're the attorney, you're providing us with the information. Prince, if the address is wrong, if you're saying you live at 27 Jones Circle and on the carry it says 1 Smith Street, the bells go up. And we have a protocol. We have to follow. Following the local police as to we are telling me you're living on versus what it says there. And if you did not register, next step. Big issue again, people come into the probate and family court, we do the record check. I wonder sometimes what they're thinking, or whether they think that we have access to it. We must have a minimum of 10 to 15 warrants cleared up every month. People come in, outstanding warrant. Protocol is, have to have them arrested. Right in the middle of the situation, right? Follow the protocol. It's part of the Attorney General's protocol, part of ours. We have to do it. You're arrested, handcuffs, the whole thing. Just going to go back, just in case people don't know what types of cases we do.
Sorry to back
No
up.
problem.
Again, the difference between Carrie and Corey.
No
Corey is
difference.
criminal convictions?
Same records print. Terminology was going to be changed because they didn't want it to be criminal activity.
Convicted criminal activity.
Right.
They
So
wanted
it's-
a more broad picture.
Right.
Okay, good.
And they now just started to add federal cases on there. So we would have access if you're convicted in federal court.
Gotcha. Thanks.
Probate and family court. We handle divorce cases. And all the subsections that come under divorce. Custody, visitation rights, child support, alimony, distribution of assets, health insurance, real estate, pensions, and anything else you can throw in there that people want to fight about. My favorite, who gets custody of the animals.
Like that.
Visitation rights with the animals. Who gets the glasses, the Elvis pictures, and any wild things that you can think of. Guardianships, minor children, guardianships of the elderly. I don't think there's anybody here as old as I am, but I'm going to be 59 in a couple months. Guardianship cases now of the elderly, big booming thing. We all have parents, we have grandparents, very big issue. Who's going to take care of them? We split that off into estate situations, wills, trusts, what's going to happen. We have time to go into that. Adoptions, name changes, very big issue. Big issue about 3 or 4 years ago, bigger issue now, people try to hide their identity. Somebody files for a legal name change, they file a petition, they pay a big, big filing fee now. We have to do a criminal record check on them, to the name they are and what they want to be. Just in case they're trying to hide things. Once the court allows the name change, and if you did have a criminal record that we submitted to the court with your application, that new name change goes to the Commissioner of Probation, to the Criminal System History Board, and it goes in as an alias. So that when your record prints, old name, new name shows up. Paternity cases. Under the paternity cases, same as a divorce. Custody, visitation, child support, health insurance, the whole gamut. Right to die cases, probate and family court, family issue. Restraining orders. 209A restraining orders. And any family issues that come up that the district court does not want to handle, they sort of slide it over. And we take it. Any questions?
Basically, like, would you handle a case like burial rights if you know, if there was a deceased and family were fighting over
We've had-
a burial or cremation?
Yeah.
You would handle that.
Yeah. Go out, interview the siblings or whoever's around. You know, why does one person want this versus the other? Yes. I've actually gone to the hospital to interview somebody that might be on life support where siblings are fighting as to whether or not they should pull the plug. What's the normal reason for that fight? Money is the root of all evil. I've learned that over the years. Always a big, big fight, money. Worst cases, estate cases, where families are fighting with each other over money, over a will. I would be willing to bet that, I shouldn't do this, but I will. How many people here over 50? A few. Do we have a will? Will? Good.
I didn't have one before I was in law school, though.
Even if you have a will sometimes, doesn't work. A lot of things beyond wills as to how to protect what you want to do or what you want to happen to you as you get older or you get sick or whatever else is happening. Many cases where people have had wills and because of internal turmoil in their families, that will gets changed right away. We had a will case about a month ago in Salem. Father had big issues with his 2 sons. One son wanted his so-called inheritance up front and now. He was making a big, big scene about it. And the father didn't have the will written and have that his only will. He had it written, but he had it on videotape. Father ended up dying a month later. Case comes into court. Attorney for the father plus the 2 sons come in. One son represented, other not. The son that didn't have counsel was the one that was pushing his father that he wanted his inheritance. And the attorney for the father wanted the courtroom cleared. We didn't know why. The judge said why. You know, he says, I think it should be. We're going to show video. And the judge said, okay, clear the courtroom, and played the tape. And the attorney's asking questions, and it's on videotape, and you have sound mind, the whole bit that goes on. And have you decided what you're going to do with your estate? And the estate was worth about $200,000. And what are you going to leave your son so-and-so? And that was the son who was fighting. And what he did was, on tape, was this. I was shocked. The judge was shocked. I was like, okay.
tell that means.
And now is the end of the tape. Okay, see something new every day. How do you challenge that?
Well, right, how
Some
did he?
coaches have
Didn't have a challenge. Plus, they had the written will where he got nothing.
No.
So he got nothing.
Did that make it before the judge? How did that make it before the judge?
Contest to the will, distribution.
And the other guy wasn't represented.
Right.
The guy that was contesting, so it's kind of easier to get stuff in when there's no attorney on the other side.
Big issue, representing a client. Be prepared. How do you become prepared? First thing is, meet your client before you come to court. Again, I said I've been doing this for almost 30 years. I still have attorneys coming to me and saying, do you mind calling my case? Well, why? Because I want to see who stands up and see where my client is. They might have met them once, or they might have talked to them on the phone, and they're going to meet there, which I know now papers are not filled out, and it just prolongs, and it irritates attorneys on the other side who are ready to go when nothing's done. How do you prepare these when you've never met your client? We know what these are? Financial statements. It's like the Bible, probate court. Money's the root of all evil. These here, if you gross under $75,000, you're lucky enough to have a client that has one of these, you might get paid. Has to be filled up. Every single line, both sides signed off on, and any additional information that might help to go along with these. It's like attorneys have never seen these before. They fill them out when they come to court. Their clients don't even have half the information. So how do you do a job in representing your client when you don't have the information? It's very difficult. If you meet with your client, you should be able to prepare your client as to what the possibilities are and what could happen. You're not always going to get what you want. You got to tell them what the options might be. What could happen? How much weight does the probation officer carry when they're making a recommendation to the court? Do we know?
A lot.
They would not refer a case down to us to sit down and go over the issues and try to resolve it, and then not take our input. So that has to tell you something. That if we're making suggestions, we're making the same recommendation or suggestions to the court. So that has to give you some insight as to how to prepare your client. Obviously, you're going to have a stand when you come in. You're going to fight for your client. But if there's no agreement of the parties, the probation officer is going to make suggestions or recommendations. You still want to go up and fight that case, you can. But the judge is going to see that same recommendation and might put some weight on it. Last thing on preparing your client. We're coming towards summer now. Try dress. Doesn't look good when you're coming in, guys suit and tie, women dressed professionally, and your client comes in flip-flops, shorts, t-shirt. Doesn't work. Do I see it? Doesn't mean now that your client, if it's a guy, has to come in wearing a three-piece suit, but at least look presentable. And the same thing for women. It's amazing what you see. And if you want to make an impression on the court or court personnel, prepare your client as to how to look, how to act, and at least not make a scene in front of other people or when they see the other party coming in and spitting and punching, everything else that we have to do. Any questions? No? Along with the financial statements, the big issue we talked about was child support. And how do you determine child support? Anybody know? Guidelines. Guidelines change every few years. They're now visiting 5 sites in the state to try to revise the guidelines again. It's amazing how many people cannot add, subtract, divide, and these are attorneys. So it makes it difficult. Oh, I don't have a pen. I didn't bring a calculator. And when you see it every day, it's just, what do you do? All right, I have to make it. I'm looking at you and I'm going to make my first impression. You don't have a pen, you don't have a calculator, you don't know how to divide. Or maybe law school doesn't have a math class, but at least practice. Many new attorneys come in and they want to have a class. We do have bench bar meetings. They want to know, how do you do this? How do you compute? I don't take the guideline sheet. Everybody's seen the guideline sheet, yellow form usually. You flip it over and it says, multiply by 27%, add 3.2% if there's 3 children, go to another. We don't do that. We use the cheat sheet. Everybody should have this. Should be in your briefcase or whatever you carry. Makes it a lot easier. And might be off $1 or $2. Courtroom has it. And I would assume most of us are computer literate. Everything is now there. Not that everything that you can get online is totally accurate, but it'll help. And we're always there to try to help. We are, my office is. I have 15 probation officers that work for me. We cover 3 sites. We cover all 40 cities and towns in Essex County. We're going there. Another issue of child support, these packages. Under the Social Security Act, now every state has to have a collection agent for child support. So the receiver of the support has the right to pick the way they want to receive their child support. Directly from the payor or obligor of a non-custodial parent or whatever terms you, they use a lot of other terms that I don't want to say. So you have to make a choice as to what packet you're going to fill out. The small packet is, I don't want the Department of Revenue involved. If you do want them involved, you have to pull it. Now, I've been dealing with the Department of Revenue for about 15 years. We do not have a good relationship. I've been sued now already twice by the Department of Revenue. Legal stuff.
Where do they sue over?
Commissioner of Probation, we had a contract with them where we have probation officers that do some of their type of work. If somebody's not working, they're going to need child support. They have to report in to a couple of people in my office. The Commissioner of Probation now is severing the ties with them in negotiations. They're now in the middle of negotiating this year's contract. A lot of people, initially they want their money paid through the Department of Revenue, say it takes a lot longer for them to get their money, and it does. If in fact the non-custodial parent or the payor is paying for multiple children, different families, that money gets thrown into a pot. And the computer spins it around, and then this. So I'm supposed to pay $100 a week to her, $75 a week to her, and I send in a check for $70. Who gets the money? They call it a posting hierarchy. And it goes into the computer, and they determine how the money's split. Now technically, if she brings me into court on a specific case and I send a check in with her name and her account and her docket number, technically it should go to her. Doesn't necessarily mean it's going to happen because of this posting hierarchy. The law also says that first families come first when we determine child support. So technically, that obligation could be higher than the second family's obligation. And in some cases, the third family, in some cases. So, unfortunately, the money that gets sent into the Department of Revenue doesn't really get distributed the way it was meant to be. So you got to be very careful when you're instructing your client as to how they should initially receive the money. If you have a person who is a deadbeat and is not going to pay, and you're constantly bringing that person into court, you might just pass it off and say, well, the Department of Revenue will help you. Have any of these people been there on block day?
No, actually, no. That because we have classes on Tuesdays and Thursdays. Those are usually days we don't go.
If you want to see a site,
That is a sign.
you go to Lawrence because it's closer, or Salem. Every other Thursday we alternate in Essex County because the other days go to Middlesex, where they bring in all their cases. It's a minimum of 100 cases on block day. Block day is when they're determining child support, whether they're doing genetic marker testing for paternity cases, whether they're bringing in complaints for contempt. Now you figure there is at least 2 parties, maybe attorneys, all the brothers, sisters, girlfriends, boyfriends, grandmothers, and there's a minimum of 100 cases. And we're in Salem. We're on the 2nd floor of the Department of Revenue Code. The line goes all the way down the steps, out the door, down the sidewalk, and the same day at Lawrence. So if you want to see a site, see what day it's in Lawrence or in Salem, and just come and visit. It is just wild. And it doesn't matter who you are, or if you're an attorney, you need to check in, you're waiting in line, and you're waiting to be called. So, if you have a case on in court, again, be prepared yourself, instruct your client. You can't say, I gotta be at work at 11:00. It's an all-day affair. So just make sure you're there, and it's an all-day affair. If you're lucky to have your case heard early, you get in, get out, it's a bonus. Questions?
I'm interning for a lawyer out in Chelmsford, and we have a contempt order for child support. You know, the father hasn't paid about $70,000, but he had paid rent for the family because he was living with them. Does the courts, like, will they substitute stuff like that? Instead of paying child support, he can pay rent?
Most judges would want the actual support order paid, unless you're gonna come up with some sort of an agreement and say, we want to credit him for that amount of money because he's paying. We have people that, when they take the kids on visitation rights and they buy them an ice cream and take them out to dinner, they take that bill and they subtract it off the child support and say, well, I took Johnny out, it cost, $30 for dinner and 3 of us went out, so $10 comes off the child support. No, it doesn't work that way. Or sneakers or whatever. Child support obligation is child support. We have some guys that want to know where their $50, $100 went and want an accounting from the custodial account. Yeah, it doesn't work.
Would it be fair to say that most of the attorneys who appear in probate court are court-appointed attorneys?
None.
So how to say, like a mother who was fighting for child support from her deadbeat husband, afford to pay an attorney on average $150, $200 an hour? So that
Why would you charge $150, $200 an hour just starting out?
Okay, let's say, $100, even $100 an hour.
Why would you charge $100 an hour if you're just starting out?
$575.
Okay,
Go the other way.
It's more like 300 or 400.
even if there were minimum wage, I'm here to say that most of these people probably couldn't afford afford to. I mean, if you spend 8 hours, you know, in line in probate court, waiting to get in front of an attorney, you know, I mean.
Sometimes it's not worth it.
Yeah.
We,
So-
way
so-
back,
So basically, I'm just wondering, why would any even new attorney want to go to probate court, decline to probate court?
You mean on a.
out of the goodness of your heart, you're opening up a business. I don't know if I should say this, but I will. There are some attorneys now who are associated with established attorneys, and when they get a case initially, they have the supposed client fill out a financial statement, and they charge based on what they think they can get. So it's like a sliding scale. There are a couple attorneys now who started out probate court. Everybody always goes into real estate. Do some criminal work, go here, go there, now they're back. But they're doing allegedly uncontested divorces for about $200 because they know they're going to get it. There's not a lot of work to put into an uncontested divorce. I could do them in 10 minutes. I could do the paperwork in 10 minutes. But I know the situation of overhead and insurance and equipment and secretary and everything else. So you have to be realistic. I see some of the attorneys and they say their billing rate is $300, $400 an hour. They never get paid. They might come and represent a client for that initial time. They don't get paid. They never come back again. So it's not like you don't want to start off a business and try to make money, but I think you need to be realistic initially. You have to get yourself known. You have to be realistic in the way you are trying to negotiate a case. You can't be gung-ho and your client is totally right all the time. It doesn't happen. Because if I hear that, the next time I hear it, like, oh my God, here she is again. This is not going to work. And the probation officers that I might assign to the case come out and they start yelling at me. I'm not dealing with her. And it's not the client, it's the attorney. So when you come in, or when lawyers come in, and they're in my hallway in Salem, which we call Heartbreak Alley, and they look initially in the morning, and we have 30, 40 cases on, and they see maybe 3 or 4 or 5 attorneys down there, and there's 100 people, what does that tell you? It's hard. It's hard for us because now we're dealing with people that don't know the law, number one, don't have any paperwork filled out, and now you're trying to hold their hand and process cases, you know, all day long, and it just doesn't work. So, depending upon how you're going to proceed, and I know it's tough to get started, what you're going to do, but you've got to be realistic. You got to know where you're going, got to establish yourself.
Does the court revisit that question off and on about how much to hold pro se litigants' hands? I mean, it seems like that would be where a lot of the bottlenecks happen in the court system. Why not just say to them, we can't help you, here are the forms, we can't help you.
We cannot give you legal advice.
Right.
We can give you the forms.
But
go see the lawyer of the day.
But don't a lot of clerks make it bend over backwards and make an effort to try to...
It's a mandate by the legislature, it's a mandate by the chief justices of the court to try to assist. Is it a pain in the neck? Yeah, because they don't want to listen to what you're saying. Lawyers don't want to listen to what we're saying. So why should the litigants be any different? Don't say litigants. But it makes it very difficult. It makes it a lot more difficult for attorneys who are representing a client and the other side is not an attorney. So it becomes very contentious, and most of the time you don't really accomplish it. Because if you're supposed to meet the other side or have a 4-way, which ends up being a 3-way because there's no attorney, how do you accomplish that? You have to try. You have to try to meet and lay out on the table what you have and what you're looking for in order to try to resolve the case, versus meeting for the first time in court and then trying to scramble and try to do a good job.
That's actually a very difficult thing. I had found myself in a modification case a couple of years ago where the other side was not represented. And not only not represented, but she had a history of falsely, it seemed that was the judge's findings, not just that was my client's position, falsely accusing my client of abusing her, abusing the children, and she had a mental health history. And the judge's pretrial order was sit down and talk prior to trial and mark exhibits and stipulate exhibits. Impossible to do with someone who's unrepresented. Every couple of minutes she'd be asking me, well, should I do this? Well, is this okay? Should I, what do you say? Can you give her any advice about what she should do or whatever? Could I? No, I mean, of course I can't. So, and then I don't want to be in a position later on for her to say, well, Attorney Condurelli said do it like this. So you went to court, of course, with my list of exhibits and a very angry judge that I hadn't come up with marked, and which I think you just don't understand until you get into the dynamic, how impossible that is for you to do with a pro se litigant on the other side, because it's just no win. You know, you're not doing your client a service because the judge is going to be angry that you didn't exactly do what she asked you to do in the order. And on the other hand, you've got this other person who might claim that you advised them to do something that, you know, you didn't and you couldn't. So, you know, it's just lose-lose all around. So I don't know what to say about that. You know?
I don't want to scare you as to what way you're going to branch up, what you can do. Very rewarding. It's a tough way to make a living. Family cases never go away. We see cases in generations. We see the same people for years and years and years. And as they change the age limits as to child support, now up to possibly 23, you're carrying these cases forever. And sometimes in our little circle behind the doors, like, you wonder whether people bring cases forward just because they want to see the other person. I mean, very, very strange. What happens and why it happens, and why once a month you see the same people all the time. So now I'm at a point where I might have 4 or 5 cases where the parties are older than I am. So when they come in, I said, make sure I know when you fill out your appearance form, because they're all pro se, that you put down your correct address, because I'm inviting you to my retirement. Because I've seen you for about 20 years. You know, and try to lighten it up a little so we can get things rolling. Visitation rights with an animal. How do you resolve that? Even custody of an animal. A dog. How do you resolve that?
Do you spend your time on that?
They had a case a few years ago.
Which one it goes to?
Pardon me?
Who to live against the dog or the cat goes to?
You got it. That's how it happened. Judge ordered, nope, nobody would bend. They had to bring the dog to the courthouse. It was in Lawrence. We used to be at the Superior Court instead of where we are now at the Fenton Center. There's a little parking lot. And everybody know the Lawrence Court? The Superior Court.
It's across the
Right
street.
before Cafe Azteca, there's a little parking lot.
Walkway.
The judge, court officer, me, 2 parties, and a dog. The judge says, well, I have to give the dog to the court officer who stood in the middle of the parking lot. One party down there, the other party down there, and when the judge said, when I count to 3, both of you start calling the dog.
Who represented the dog?
I think I did. So, they called the dog. Dog went to one party. They housed it. How do you make a determination?
I know this sounds very amusing, but people do get very emotionally attached to their animals.
Very.
I suppose that's just some of them. I mean,
Are we all open-minded here? We had a case in Peabody about 6 years ago where a gentleman came home and he heard some barking and crying and whatever, looked in the window, and that's where the bedroom was, and his wife was there, and the German Shepherd was in there.
Oh my God.
Dog comes out, he kills the dog in the driveway. Police come, arrest him, whatever. I want to know what was happening, but it became a criminal case and a probate case because it ended up being a divorce case. But the issue was the wife having sexual relations with the dog. High-profile cases. Essex County, very, very high-profile area, whether you believe it or not, because the law school is up here in the northern part of the county, but we do have probably per capita one of the richest counties around. When you're talking about Manchester by the Sea, Beverly Farms, the Hines, Salem, Saugus, whatever, we have had very many high-profile cases over the years from a lot of professional athletes that live in Essex County, a lot of executives, presidents of corporations, judges, all come through the same system. So you could be down in a hallway and sitting next to a professional athlete or a judge going through the same misery that everybody else is going through, or big-time corporate executive, who a lot of you probably would know. The athletes is something different because hockey players, some baseball players, you might not know without their number on. Basketball players, you know, only because they're a lot bigger. And it's amazing what happens sometimes, and we try to expedite those cases faster because people sort of congregate around and they want autographs, even though you're in a court situation. So we try to put them aside and get things done and get them out. Probably one of the biggest high-profile cases I was involved with a few years ago was the cross-dressing doctor, Dr. Sharp. I was the original one that helped the woman get the restraining order. And then right after the return day, he went to the house and shot her and killed her in front of the kids. Pretty tough case, because after that situation, then we had to deal with what was going to happen with the kids and where they were going to go. And it was a constant battle because he wanted the kids brought to Walpole, Cedar Junction now. And going out there and interviewing him, and we just didn't hit it off, he and I. But pretty tough case when you're initially involved in going through it and seeing what happens, after 5-6 months. Then it became an estate case. He was very, very wealthy. He owned a lot of hair removal places that are in strip malls. He owned 5 or 6 of these dentist shops that are in strip malls. Multi-million, but just stacked. Huh? Also, 2 weeks ago, had to deal with the case from Lynn, where the gentleman pulled the mother of his 2 children into the elevator and lit the gas canister, and the thing all blew up. Had to deal with that case. What was going to happen to the kids afterwards? Became a guardianship situation. Today in Lawrence, you weren't there.
No.
I think Dick Consoli was helping people out. 3 Spanish women come in with 1 word of English through some of the stuff, the courthouse. Biological mother tried to commit suicide. She had 2 razor blades, was slashing herself in her neck. She was living with her mother, and she had 5 children by 2 different fathers. And everybody was in the house when this was happening, when the police were called. So, pretty tough, emotional cases come in. And there's going to be situations where you're involved in cases that are going to have restraining order issues, or big fights over money, or intimidation. You have to be able to be strong and be able to know what to do, how to do it. Number one, to protect yourself, and then to protect your client. We have a lot of people that don't say anything to us, or attorneys, when we should know ahead of time what could happen the day you're coming into court. Give me a little tip so that I can have security, court officers, whatever. Just to try to make, the presence there so that, everybody feels a little safer. Again, in Lawrence today, we had former New England Patriot football player. Very violent, very violent. But I was tipped off the day before, last Friday, that the case was coming in. And I had extra security there. But this guy, big guy, now he has 5 kids. And he thought he was going to make it. He only played 3 years. He's nothing. Restraining orders, jail, back and forth, but very violent. And attorneys on both sides are female. He's had 3 attorneys, always female, and tries to intimidate every single one.
I understand that you have to meet the income guidelines to access the mediation provision.
No, that's just lawyer
No,
for the
lawyer
day.
of the day. Lawyer of the day only.
Oh, okay,
Everyone
mediation,
does
getting into
Yeah.
mediation, there's no income guidelines.
Yeah,
So,
every contested
Every
case.
contested case, for the most part, comes down to money. So, in order for us to deal with these contested cases, we at least need to know what the law says about how we're going to proceed on it.
What's usually, besides the pets and everything, what do you see as most basis for being contested? Is it alimony, is it non-marital division?
Well, custody is usually a big contested issue, but when you break it down, most men don't want physical custody of their children, and they're only using it as a ploy, maybe not to get child support. So once we get by that and explain what the law says about shared legal custody, and then who the physical custodian might be, then we get onto the visitation rates and then child support. Money is still always a big contest. Alimony, not a big issue. Not, I would say, at the most, 20% of all divorce cases might have an alimony part to it. Because if a case comes in and everything is contested, including child support, alimony, custody visits, the child support component always comes first. So we have to determine child support first. That comes before alimony. So once we make that calculation, and there's no real guideline for alimony. We have a guideline.
He asks me about this every class. I wonder if there's a, he asks me about this every class, and I answer the same way. There are some people that say that, there's a formula out there, but it's not a predictable thing.
It's not a predictable formula. Judges use anywhere from 30 to 45% of the difference of the gross incomes. Okay, so I make 1,000 a week. She makes 500 a week gross. The difference is 500. So say we take 40%. 40% of that difference is $200, right? But if we do the guidelines for child support, and that comes to $195 a week, what's the element? $5. So elements fine. And so we're looking at the difference in the computation. There's no formula. There's no law on it. Little rule of thumb that, you know, we play around with. Some judges, nobody will say that they help. But it's the difference of the gross and how it's going to proceed. Biggest issue that prior court cases, divorce cases and paternity cases didn't deal with, and the changes have started to make it into these agreements, maybe 5 years ago, has been who, how, when are we going to start talking about further education of the kids? And not college, only high school. A lot of kids go to private school. How do you determine who's going to pay what? Pick on something else.
Actually, I was gonna ask if you could walk us through a timing. If there's a contested divorce, someone's filing pro se, what is the timing of the actual filing the paperwork? So they go to the clerk's office, they file, they need to get the summons, and that gets
That's
sent.
simple. Let me just finish this.
Okay.
That's simple.
Okay.
How do we determine cost of who's going to pay? You from this area? Central Catholic High School in Lawrence, which is $8,000 a year now, I think.
Yep.
I don't know, split it in half or figure out who would have paid how much if they were still together.
How would you figure out who's going to pay if they were still together?
Well, if one person didn't make anything and the other person made the entire income for the house, you would assume that if they were still together and if that was their decision to send their child to Central Catholic, that would be the only way to pay for them unless the other person had money aside.
Okay, so I'm working and you didn't work.
Mhm.
Why would we send that child to Central Catholic? If we only had one income?
Well, maybe you big corporate person, made lots of money.
So you're right. But what happens is sometimes people go way beyond what their means are, and then they bury themselves even more. Rule of thumb on payment. For anything out of the ordinary, including orthodontia, which is never covered. People talk about health insurance. Judges don't consider any orthodontia health insurance. It has to be labeled separately. Health insurance is what would be covered, and most health insurances don't cover braces and things like that. Most do not. So our rule of thumb, and this is a tip, people pay proportionately to their gross incomes. Do I have to explain that?
But does that include college tuition as well?
After all loans, grants, scholarships, grandmas put aside money, because once a divorce occurs or a separation or a paternity case, people do not communicate in order to fill out the proper forms to maximize what they're going to get as freebies. My son's finishing up his junior year this year at Merrimack College. I went to Merrimack College 100 years ago. My daughter graduated from Bentley College 3 years ago. What a pretty sight. When my daughter left Bentley 3 years ago, it was $42,000. Merrimack next year is going to top 40, I think. But if we're doing proportionate to gross income, and I'm making $1,000 a week, and she's making $500 a week, that's a pretty simple way to do it. I make 2/3 more than she does, so I'm paying 2/3, she's paying 1/3. We think it's the most equitable, but still, how do you come up with that type of money? Or do the kids go to those schools? We had a case 4 or 5 years ago, Andover case. Father was a professor at Northeastern. Mother sold real estate. Child wanted to go to a big school in New York. Could have had a total freebie at Northeastern because Dad was a professor there. Mother says, no way. She wants to go here. That's where she should go. So what happened?
Mom gets to pay.
Mom didn't realize it. She was making more money than he was. He was a professor. She was selling real estate. She was making more money. They could have had a freebie. Now she had to pay, I think it was like 60-40. So people don't communicate when it comes down to this stuff. But the rule of thumb is proportionate to your gross income on anything ordinary, unless it's specifically stated in an agreement that becomes a court order, which always could be modifiable due to changes in circumstance. And the way things are happening now with pensions and retirement, people let go, and doesn't work. And you can never save enough money to pay for education. Nobody can. You know, even though they say you got to start when the child is conceived, forget it. You're not going to have enough money to pay. If you go into a private school, it's going to be a minimum of $100,000, and within the next 5 years, say $150,000.
I'm just going back to that. You could see where two parties break up. One of them isn't working at the time. One is, and then over the years, as the child's getting older, maybe goes to high school. Now that person has a lot more time, goes back to work, now starts making a considerable amount, but there's no communication between two spouses or ex-spouses. Then all of a sudden, the other spouse realizes that there could be a modification now. The kid's still 17.
Right.
Do you see that a lot?
Yep. And just the opposite way too. Somebody made a lot of money, and then job is terminated. And most places now that are doing away with pensions, big corporations doing away with pensions, very tough. Unless you've worked out a way to, like you would have to do, 401ks, mutual funds, stuff like that, start your company, you know, you don't have a pension plan for the most part. Social Security is not going to do it. So you need to supplement your retirement from day one. Whether you believe it or not, time just flies by because you'll never have enough. I went to a seminar about a month ago, and they're still predicting that if you start at age 25, and if you plan on retirement at age 65, and you put away 20% of your gross, and I don't know how people can put away 20% of their gross income with taxes and expenses, that you could amass $1 million for retirement. They have this thing all projected. I think that's only with an 8% return on your money. So even if you didn't need $1 million, and you could put 10% away, but people do not save. People don't save. They live for the day. We all want to do what we want to do when we want to do it, but that has to be a bill, a regular monthly bill that you pay out, a certain portion of your income or your client's income has to be a bill that you're going to pay, whether it's going to be to your 401k or to your mutual fund or whatever. But the proportionate to your gross income stuff, you never have the money. And sometimes you have to instruct your client that you cannot afford to send your child or children to these high-priced schools. You'd hate to say that your child can't have braces, or tell your client that who's going to pay the $4,000 or $5,000 that it costs them or more. But things happen, and unfortunately, guys that say go to jail, I'm saying guy, goes to jail for not paying the child support. Contempt brought, didn't pay, goes to jail. 90% of those guys are in there 2 days. I know because the purge money comes to me from the jail. So I know at the end of the day, contempt day in our court is Thursdays. I know how many people go, and the jail contacts me as to so-and-so's being released, so-and-so's being released, so-and-so's being released, because the money's coming. So is it an issue where you do file the complaint for contempt? Absolutely. 90% of the people don't follow the other rules that go with the complaint for contempt. Motion for counsel fees. Motion for cost of serving a summons. Motions for a lost day of work because I had to bring you into court, you jerk, because you didn't pay my child support. Do the judges rule on those things? Absolutely, if they're in front of them. I'd say 9 out of 10 cases, you never see those motions. You never, ever see those motions. They've always been there. One of my jobs now is to monitor when the court orders a guardian ad litem to do a report on a case, whatever the situation might be. Chief probation officers in the probate court, there's only 12 of us, 12 counties, have to monitor these reports going out to people. Could be an attorney, could be a shrink, could be anybody, whatever their expertise might be in that particular case. We are the monitor, only us, as to when the assignment was made, when the due date is, to get it in, then to notify the attorneys it's in order to proceed with the case. We are now having attorneys contact me saying, I'm not releasing the report. What do you mean you're not releasing the report? Why wouldn't they release the report to me? What was that?
They didn't pay.
Somebody didn't pay. One of the clients didn't pay. The client somehow, in meeting with this professional, is getting the sense that that guardian ad litem is probably not going to recommend in their favor. Why the hell should I pay? But the court order says 50-50, 70-40, whatever it is. So the GALs are now being instructed. It's a court order. They're ordered to pay. They don't pay, same thing, file contempt. And the judges are saying, wait a minute, this isn't child support. I made this order for this person to perform a function for the court, and you're disobeying the order. Guess what? Going to jail. And believe it or not, 50% of the people who don't pay are women. There's only one women's prison in Massachusetts, Framingham. And they go. Any questions?
Are you the office that keeps the GAL reports? They can't be released to the attorneys and whatnot, but they can read them at the courthouse if they...
They come into my office, we process them, we notify the parties or attorneys that they're in, and then it goes to the registry of probate, because they're at the clerk's office. That's where they go. Where do most attorneys go looking for them?
That's what I was, yeah, that's what I thought.
But people say, oh, the GAL report is in. Did you get a letter from me stating that it was in? No, I heard from somebody that it's in. But on the actual order, it tells me who the attorneys are, or if the parties are pro se, it gives you your name and address. And when it comes in, letter goes out saying, it's here. You know, come and read it, mark it up, do what you have to do.
Can you tell me how you handle continuation of health care benefits that are interrupted because of the divorce?
Healthcare, very big issue because of what? Cost. COBRA is a very big thing that nobody can pay for. I know only because of my daughter was in the midst of graduating from college and then not having a job. So she could have continued my coverage of COBRA. In fact, the law was just changed so that it extends, which makes it a little easier. The court sort of has eased up on that, but wants coverage. And a lot of people now have been able to get mass health for that short period of time in order to cover that. But health insurance is a very big issue because of a lot of places don't cover certain things. Where we are here, we have cross-jurisdictional boundaries where we have New Lawrence, Andover, then we jump into New Hampshire. New Hampshire Blue Cross, some places down here don't take. So we have problems as to coverage. If I'm supposed to maintain coverage for our line of children, and I work in New Hampshire, and I have New Hampshire Blue Cross, but she takes the kids to Children's Hospital in Boston, I'm might not be covered. Now, how do you resolve that? Sometimes we say, if she's working, what I would have paid in New Hampshire, I give to her, but she has to maintain coverage. So instead of me paying up there, I'm giving her the money to cover the kids, so that at least they have an advantage of maybe seeing where they go. But COBRA is a big issue. Nobody can afford it. With this new healthcare stuff that's going on where everybody needs coverage, we are hoping that it's going to make a big difference. And we haven't really had any training on it because I think they're still working out the kinks, but I think that's going to save a lot of headaches. Anything that anybody wants to talk about? No? Okay.
You said earlier that you have a lot of cases now dealing with illegal immigrants. The majority of them probably don't know English as their second language.
Right.
That must pose a lot of problems. You're saying you're bringing an INS agent?
Well, we're going to start. We have a lot of cases that have that situation, and we have an INS agent coming into our next staff meeting to give us some info as to what we do, what we need to do if we find out that somebody is illegal, and what the next step is, process-wise.
Because usually off the start you won't know.
Right.
You find out till you.
And the only way we usually find out that somebody is illegal, case goes into court, and usually it's the woman that says, he's illegal, but he wants custody or he wants to visit or whatever. That happened today to us. But, you wouldn't know it. Language is a big barrier. Lawrence, with the Hispanic population, big barrier. There's not always trial court interpreters around. We have signs posted everywhere that if you don't speak the language, you have to file a request for an interpreter to be sent from Boston. Probate court is always the last one to get them. They go to juvenile, to district, to superior, then they come to us. You could be there at 8:30 in the morning waiting for an interpreter, and by the time they make the loop for all the courts, they might show up in our building by 2, 2:30, 3 o'clock. Very big problem. In Salem, we have a big Russian population now in Salem, Mass. Hard to get different language interpreters, and the courts sometimes will allow, if you bring a friend, if it's sort of an uncontested situation, but if it's a contest, they're not going to allow me to bring her because I brought her. We don't know what she's going to say even doing the interpretation. So it makes it very difficult, and it extends the day, and sometimes those cases don't get heard. They get put off to another day, file the application again to get an interpreter sent, and hope that they get there. But causes a big, big problem.
Really should be someone on call in that building, period,
Right.
assigned to that building.
We've requested through the trial court that there's somebody there every single day just for the probate court. You have to submit a request with the name of the case and docket number in order for them to consider it. The system stinks when it comes to the interpreters. Just got one last piece, elderly. Guardianships of elderly. 2 o'clock in most of the probate courts is when they do a lot of the Rogers cases. We know anything about Rogers cases?
Only if they have been in probate court with me when perhaps someone has come in with a guardianship of a mentally ill with the request that they authorize treatment with antipsychotics, but I don't know how many of them that here would be.
Treatment of people. I'm not going to say one or the other or even antipsychotic drugs. Most of those cases are heard at 2 o'clock. Usually attorneys are involved in the case. Big issue because what stress it puts on the families on these types of cases is unbelievable. And if anybody here knows somebody or parents or anybody else that is going through nursing home situations or dementia or Parkinson's or Alzheimer's, tough, tough situation. In order to get people to move and see a professional, you people, to have the proper work done, powers of attorney, healthcare proxies, wills, trusts. When I go out and talk to groups, I don't think 10% of the people you speak to have anything done. And it's a last minute thing. And when it comes to a nursing home situation, the federal law continues to change, and I'm not an expert, even though I had both my parents in that situation. But the federal law keeps on changing to make the period of time longer and longer as to when you had to do something to protect what you might have as an asset, correct? I think it's up to 6 years now, and I heard it's going to 9 years. That means in advance you have had to have done something to protect any type of an asset. And I hear some of these ads on TV and radio, and it's law officers saying that, you know, we are the ones, and we'll never have to lose this or that. I don't know how they can do that or how they can maneuver protecting a piece of property or an asset. But I know there are ways that you can try to help preserve by forming a trust, you know, changing and giving away gifts or partially doing a distribution that you might have done, you know, if you passed away or will or whatever. But if you do have parents at home and you're coming here, you know, look at it. Or if you have friends, or, you know, it's not that you're prying into what their business is, but I think we need to try to help each other out and see what's going on. It's tough when you're in it yourself in dealing with your own parents. And I know my mother had a DNR, do not resuscitate. My two sisters and myself, luckily, we're all on the same page. But when you have people that don't agree as to what should happen, and that individual never made up the ground rules for you. My mother did make up the ground rules for us. Very, very hard when you have to deal with your siblings as to what's going to happen and how it's going to happen. And, you know, these healthcare proxies and things like that, pretty simple as to a person telling you what they want, how they want it done. When you hear it from them, why would you go and do something else after the fact? So it's something to really look at, and I don't know if you'd even entertain doing that type of work, but pretty interesting as to what's going on and how it's happening now. Anything else?
I'm sorry, can I ask you again, just to go quickly through, how does it get from the filing and service to your office?
Sorry.
Okay.
You come in, you file the complaint. Massachusetts in the probate courts is now following the federal courts and the Superior Court on time standards. So there is a timeline as to when things are going to proceed and how they're going to proceed. Once you file the complaint for divorce, you're going to receive a summons. That summons, along with the complaint, has to be served on the defendant. Not by you, but a sheriff or constable, all right? Whatever the specific serving authority is, even if it's out of state, every state has their own. The procedure is normally up to 20 days on most of these summonses, 20 days after the date of service. You can mark up motions. You mark up motions, rules apply. 7 days in hand, 10 days, last than usual. Some judges are very specific about how notice was given. You have to be able to produce the certificate of service. very amazing. People come into court, and we say, okay, what are you here for this? Well, where's the proof of service? Oh, I left it at my office. And these are lawyers, not pro se litigants. So once the service is done and you're bringing in the motion for temporary orders, in Essex County, in my department, no matter where we are, Lawrence, Salem, or in Newburyport, we can assist the attorneys by having a pretrial list there. Once your temporary orders are heard, if you have an agreement in my department, you don't need to go before the judge. We proceed and we pass those on as long as we sign off on the agreement, because we know what they have to say and what paperwork goes on. You will not leave my department without getting another date, because we have the judge's pretrials. Other counties, you need to go around to the court computer there and try to find where the list is to get the next date. So they have dates assigned to already, case management or pretrial. If you have an agreement, you go to the next step. Go to the other ones. Keep on doing it. But it's not that difficult if you follow procedure. If you forget, come in and ask. We're there. And we are lucky in Essex County that we've always been able to progress about not having to make attorneys go wait in line in court all the time if they have an agreement, unless I want you to go wait. But I have an agreement, I don't care. So if you have everything together and we sign off on it, you're gone. So if you come in, your case is called by me at 8:30, you're in with the probation officer, you have an agreement, signed, sealed, and delivered. By 9:30, you could be gone. Judge isn't even on the bench yet. It happens. So preparation is the big thing. Have all your paperwork. You come in. You can be in and out in no time. Big issue is emergencies, stuff like that. How do you proceed? I have to be here. I have to be there. You can't be in two courts at the same time. I have to be in Boston, but I'm here. Doesn't work. So you have to be able to plan what you're going to do, what you're going to take, and how you're going to do it.
Anything else? One other thing, and I think Justin may wanted to ask this, is I think we just wanted to have some idea, or some people here might have wanted to have some idea of what the background of your staff is in terms of their other life. Like, do they have sociology backgrounds? Do they have psychology backgrounds? What kind of, what are they trained?
The probation officers?
Right, your staff, right.
15 probation officers in my office, 2 assistant chiefs, and myself. So there's 18 of us. 12 of the probation officers have a minimum of a master's degree. 12 of them used to be social workers for the Department of Social Services, so they've seen almost everything, and they've come into the probate court because that's where they fit. One has a doctorate. We had one that had a law degree that moved on. Again, we have to do 15 hours of training every year. That's not what we want to do, but what the Office of the Commissioner tells us to do. Plus what we bring in ourselves and changes of the law, whatever. We're lucky in our court, the judges are pretty easy if we want to have them come down and just go over certain issues that might come up on a specific case. A thing we didn't touch tonight, removal cases, removing a child out of the Commonwealth, things like that. A lot of changes, a lot of controversy over what the law really says in a divorce case versus a paternity case, where you can go, who says you can go. That's a topic for another day. And it's very, very specific as to what the rules say now, because there has been some changes in the last couple of years. But I'm very lucky because the staff that I have in my office are pretty well educated, always keeping up as to what the changes are in the law. We're not always going to be on your side on a recommendation. We don't hold it against you, don't hold it against us, because you have to deal with us for many, many years. And we want to be able to just roll with it and work it out. Some people do take it personally. Why, I don't know. I say we're just like an umpire in a baseball game. We call it the way we see it. You know, we're listening to two sides. We're making a judgment call for a recommendation as to what's in the best interest of this case, whether it's the child or the elderly person or whatever. Not to say that we're right all the time, but you know what? We're doing this every single day for 8 hours a day. You people might be in an office and you're taking cases and you're trying to see where you're going to go and how to do it. We are doing this every single day. We're doing the same types of cases, but everybody's situation has a little different twist. So, got to give us a little credit too. It's tough on us because some of the things we say and do and recommendations we have to make, we're the ones that are making the recommendations. Not you. Can you talk to us about it? Absolutely, as to where we're coming from. And that works, because that helps the negotiation. You know, why are you recommending that, or why are you saying that? Instead of just storming out, you know, you made a recommendation against my point. It doesn't work that way. So we're there, we're willing to talk. We've had many attorneys that want to come into a staff meeting, you know, go over issues. Talk about why you do this, why you do that. How do you come up with this? Like the portion of T. Wilson. Well, I never thought of that. Well, there has to be a way to come up with something as a starting. You know, distribution of assets, starting point is 50-50. But why do some judges go lean one way or the other for one party? You know, there's certain conduct issues, conduct of the parties, this, that, what you brought in. We didn't get into situations where in Massachusetts, especially in the probate court, many things change on money issues because of one thing, the Massachusetts state lottery. Very, very big issue. Lots and lots of people win lots of lump sums of money. They're not all millionaires, but a lot of them are. And we see a lot of cases where those modification papers come flying. It's unbelievable. Because everybody's picture's plastered everywhere. There's going to be a change in the modification rule that I heard last week, that it's not going to be just on your income. It's going to be how your life is being lived. You'll see the rule coming out, I think, in another 2 weeks. Legislature's ruling on, in the Supreme Court, as to how these changes are going to be made, or what's going to be able to be talked about.
Yeah, that was just last week, right? There was
It was on the news last week. So things change all the time. So before you get to practice it, we have to learn it. We have to know how we're going to apply it to the cases to tell you and then to go to the court. Any other questions?
Thank you. Family law, see you Thursday.
Thursday.
No, I didn't. I don't have that much time. I spent 2 days, 4 hours recovery. Oh, really? Yeah.
Duke Devorian, son of a monk. Duke Devor is a monk. I don't know how they got that from. I like it.
I was there.
And, I think my son enjoyed it.
What dorm is it?
He's in Santa Guy.
Oh, the brand new dorm?
I don't know how he got there, but he's in an 8-man unit.
Oh, what? And
She has 9 months.
for one reason.
So she
He was in a 4.
She's just walking.
He was in a 2, then he went to a 4.
I just have a rough week.
And,
I'll just have a
that's great.
But she doesn't have four. Me and Bobby had one.
Question here, certificate almost by GPA.
What's going on?
So you get a group of kids together, and it's a lot. Whoever, they pool their GPAs and you get, which I thought was kind of strange when it was
Yeah. You know, coordinating doesn't work.
marketing.
You know, when it goes out the window and stuff. She's really funny and then I just had to deal with two friends on, Sarah actually got me because they didn't.
I was hoping you would, they loved it.
We don't really like it. But yes, nicely. So I got my way now. We finally got a pool table after like 20 minutes.
A goldfish?
We got the pool
Oh, one
table.
of the big ones
The
that
only
you
person that
Oh,
so that's why we had to couple white brushes and everything else. Super, yes. Well, I think, you know, just one hangover over here, I was just doing some cheese. And, awesome, look at you. I know.
Get something, you talk about the alimony thing, you know.
Okay, what else?
Presupposes there's something left after child support
This one.
to make an income stream.
She missed every single ball she shot at. She did hit the ball, it was out.
And
She knocked our ball in the park.
because this is not big.
But you know, she hit hers first, so even though she hit her ball,
You know, if you get
knocked into our ball,
kids,
yeah, our ball, she hit
Yeah, I suppose, you know.
It was after Charles.
Yes.
She was like, hey,
Take a break.
you want to play for fun?
No. No. It was very nice. And then, you know, because that one ran out. I couldn't do it this week. I was with two guys and they're like, no, honey, you can't start it.
Okay,
zero. The first I did it was state. You know, X, Y, and Z. I'm like, she did scratch like 6 times. And you know, whatever, but you know, we don't scratch, but she considers that a scratch, so she takes the ball and walks away with it.
I never wrote anything down.
We just got into a ball.
So you just.
No, we argued, we actually argued, and she's like, well, technically.
Every once in a while, I'll
And
say
then one
something
day
like
I
kind
did-
of offhand, and someone in the periphery will hear it.
We did it wrong.
Say.
I didn't really hear you.
I did the minus, I was dutifully doing the
It's like
math.
twist a ball.
Oh, I'm so stupid.
I don't
Actually, what
Me
it
too.
was that.
Anyone that's ever gotten this has
No,
been
it wasn't.
telling me.
Oh,
Like
it
I said,
wasn't
the second
actually
class they
that.
gave these out to and said, go
Oh,
for
yeah,
it.
I guess not bad.
Everybody's
So
had
I
trouble
understand.
and I had
Like
trouble
giving
again.
it a coffee.
I got
They're
it.
not
I finally lost.
You probably have to just do them and read.
Alright, well, enjoy.
And then it's sort of actually
And
becomes
then
second nature.
Weekly stuff, and you start filling in $6.95 for the
So-
rent.
Oh, yeah,
We
yeah.
don't have family
Wanda,
even though no
we
one
totally
showed up tonight.
screwed it up.
Both of us?
That was.
Anything
Well,
under
you know
in
what I mean.
minus, you put 0.
Yeah, I know.
So 20,000.
I overheard one of your classmates in another class talking about your class visiting tonight. He said,
Yeah, that's what I said.
know if they could make it or not.
No one's gonna
He said,
hire
I
me.
said, just to say they would be there, whether they were gonna be there or not, so that.
Oh, really? Oh, really?
That's why I can't do it because that's how my law office
Do you know how
What?
mad I
Well,
was?
that's-
when I
yeah.
was in attendance?
Well,
Do you know how mad, I know she goes,
It's
of
more
course,
to
to
go
the
with that.
she wants to
The
go.
hell something.
It's like listening.
What do I, just because I pick on the youngest person in the room? That's not fair.
They'll do child support guidelines and financial statements too, have added things.
But yeah.
I don't have to pull my hair out in law school, and I cannot do this.
Yeah, it's not mine. I always ask the stupid question, you know. Just to clarify, oh, so does that speak for
When you said that,
Yeah.
Yes, but that stuff means
no,
stuff.
when I people do,
Come on.
I know, I'm like, I couldn't even do it like
You're
2 hours on Saturday. I was like, if people come in there and you're like, oh, I
No,
got
I
10
actually,
minutes to go.
I finished
How
it.
does it happen that they don't
Started
know for the
talking.
Oh, good.
points?
Yeah, it was pretty easy.
Yeah.
well, like
They
you said,
never
maybe
meet
they've
them
only talked to you on the
before.
phone.
See,
Yeah.
But still,
I
you
would
would
die
think
if
they
I
would.
come up.
yeah, math practice had really nice ones.
Yeah.
I actually got a decent amount of notes from them.
Right.
Yeah.
Right, like if, especially like if they're offended or whatever, and they're getting, they're getting
On
forced.
Friday,
I thought that was
Wednesday
great.
night.
That was one of the most enjoyable guest speakers that we've had.
Although, you know, a couple of days is a little better notice than if you're a criminal attorney and you're getting called from jail. Oh, okay, I'll be there in the morning.
Way
What are you
more
looking
organized than those that had our probation. Yeah, register.
Like I said, she had
Yeah, he was very organized. I think you
Yeah.
have to do
Yeah.
this.
Yeah.
Education, so he's got this routine down pretty well, which is,
I mean, the child support.
Nice and realistic too.
yeah.
Child support, I asked for divided equally.
But you know I was thinking,
I just never paid the kids that tuition.
Yeah, that's what I
Oh,
did
yeah.
too.
Yeah.
No,
But so you weren't much.
you got this
Oh, I didn't see that.
Oh, you didn't?
worker, officer, probation
But there's no way
officers,
she can do
and
it just on
they
her
all
graduate as for separate.
have an interest in having
No, I just did
a
choice.
ton of people
So I'm not her
in need of their
Yes.
services.
So
And,
where are you when she
and the courts, you know, are all kind of
She
gummed
can
up
work
with
with
these.
She can,
lots of
yeah.
citizens that
No,
aren't-
but-
I mean,
All
you gotta
right.
give people a
Okay,
chance
now
to
turn.
do what
This
they
is the
want
shop.
to do legitimately, or why honor them, why give them, give them hearing? And he didn't answer.
I know, it kills me, I know.
Which I think would basically be, well, we don't care. Well, we have to do my job.
Yeah.
They don't care what happens in court, because they just have to go to meetings and find a judge. Excellent. Not to, I mean, I'm not against, I'm opposed to it, I just think there might be something of that.
The last thing, did you mean there's new considerations for section 34? Is that more things you can put into the mix? Is that what he was saying?
I'm not sure what you're referring to, about
The
what?
last thing that Mark said was about this new, the way you're living your lifestyle.
Oh, modification, maybe, I
Modification.
think what he means, and I don't know for certain, but I think what he means is, perhaps, that, a court would entertain, a modification, perhaps on a child support issue, not just based on a change in income, but based on a change in your lifestyle. You know what I mean? Perhaps,
Either way, up or down?
up or down, I mean, I don't know why you would change up or down. If it's going to be based on lifestyle, you would think that, just like if it were based on income, you could be entitled to a modification upon a showing of changed circumstances, material changed circumstances in income either way, right? So why would it be any different if it were lifestyle? But we'll have to be watching that if that's, you know, happening, because, I mean, how do you measure it?
Right.
How do you measure it?
Isn't it a response to people hiding assets?
Well, it's a response to people hiding assets, it's a response to, well, well, you know what, don't pay me, do this for me instead, or buy my car. Okay, you know, making those deals with their employers to do extra little things that won't show up on the 1099 or the W-2. But, you know, perhaps, you know, this is what we're looking at, addressing those ways of being able to engineer a benefit so that it won't be measured in terms of an income augmentation for the purposes of child support. So that's, I would think, one of the things that it would want to address. But I have to see the rule a little bit more closely in order to know. Now, for tonight, you were supposed to prepare a motion for temporary support with appropriate supporting documents, prepare a financial statement, and complete a child support guidelines worksheet for Polly Bettina. Now, those things, obviously, you've done a motion, so I know you know now, and you have sample motions, you know how to put it together. If you want to, I'm assuming you all did this on your computer, if you want to email me your motions, just click your button and send them to me, or leave them with me, I'll look them over. As far as the financial statement and completing a child support guidelines worksheet for Holly Bettina, that we should go over. At least to the extent that you will know how, and many of you were in family law, so I think you've done it before, done the exercise before, but this is a, an opportunity to do it again. We will ask you to do this most likely, at some later point in the term. So completing a child support guidelines worksheet would entail, as Mark said to you, there is a table which was included in what I sent you in terms of the link for the child support guidelines worksheet. However, on the back of the child support guidelines worksheet, you will notice that there is also a formula. And you can follow that formula just as well. I mean, it comes up just about the same number as what you're going to see on the table, plus or minus $1 or two. The back side goes according to how many children there are, and what the income is, what the income levels are. So if you could just tell me, just quickly, what is it that Mr. Bettina earns a week, based on the financial information that I gave you?
I come up with $1,450.80.
That's right. Okay, that is what he earns per week. You had to do a little bit of math in order to just make his income into a weekly figure. That would have been it, and at that point, you either look on your table for what it's going to cost someone that earns $1,403 or $1,404, and that's what that's probably going to say is it's probably going to be, you're going to look at the line that says 1405, because not more than 1405, that's what the table says. The next number above it would be 1400, so it's either 1400 or 1405. You pick the 1405. Okay, it goes as not more than, okay, not more than, between 1400 but not more than 1405. That's the number you pick. Now, what number was that basic child support order from the chart?
397.
Okay, 394, 397, something along those lines. You also could have, as I said, use the back of the sheet, or as you saw it online, I think they show this first and then the worksheet. But you also could use this and say, well, he's 751 to the max. That's the column that you'd be working with, or the row that you'd be working with, because the other income scales are either 0 to 100, he makes more than that in a week, or 101 to 280, and he makes more than that in a week, or 281 to 750, and he earns more than that in a week, and the last one is 751 to max, and that's where we are, okay? So you would use that row. How many children? Two, so you look under the column that says 2, okay? And it says the figure is going to be $199 plus 30%. And if you look underneath, it should say that the 30% applies to all, or you look here next to the row that gives you the scale. It says the percent applies to all dollars over 750. So you do like a little math problem here where you say, okay, it's 199. The support is going to be basic support. This is only if you don't have the tables available to you. So you may be in court really quickly, not expecting to have to do this, so for whatever reason you didn't do it and you need to figure it out, you just turn it over, get your little calculator out, and this is how you figure it out. You may not have the tables with you. Well, they do have them hanging around, but sometimes you just can't get someone's attention to get it until you'll be doing this. So you go there, $199. Support is going to be $199 plus 30% of 1403 or 1404 minus 751. All right?
So that's all dollars over $750, all right? 14, and that figure would be the difference between what he makes and $750, right? So that's what the 30% applies to. So you take 30% of that figure, add 199, and that's your support figure, and that's going to come out to 396 according to the table. It's close enough for the court to accept the figure. Now, what happens if the child is over, the oldest child is over the age of 13? Julianne?
You have to multiply the figure that he would have paid per week by 10%.
So there's a 10% add-on for an older child. 10% add-on for an older child. So you get, you take the 394, take another 10% of that, and then you add that figure to the basic child support order, and you get $433 or $436 with however you did it, by the table or by calculation. So you took the basic order, you added on a 10% add-on for the oldest child being over the age of 13, and you get a new support order. Then what this next paragraph 3 instructs you to do relates to the adjustment for the custodial parent's income. The adjustment for the custodial parent's income. If the custodial parent is earning income, then the non-custodial parent who's going to be making this child support payment should have his or her payment reduced to some extent by the amount that the other parent is able to contribute. Now that's the question. What is the other parent able to contribute? What do you know in looking at this form? Is the custodial parent going to be able to contribute all that they earn? No. Martha, what? Well, they get $20,000 off whatever they make. Exactly. There's $20,000 disregard. So that custodial parent gets to earn $20,000 a year without it having any effect whatsoever on the basic child support order. All right? So this next calculation is going to actually add together what the husband and the wife are making, what Mr. and Mrs. Patina are making, and then take a look at what percentage of that is Mrs. Patina's contribution. And then if she makes enough, then reduce his child support payment by that exact proportion. But what happens here in Mrs. Patina's situation? Paula?
She doesn't make $20,000.
She doesn't make $20,000. So there's no disregard. There's no, there's a disregard, but there's no adjustment. Okay, the order is what it is. The other thing you ought to know and take a quick look at that, item C there says less child care cost annually. So she would also get credit for whatever it cost her to have those children with a babysitter while she went to work, or with a child care agency while she went to work, so that is also deducted off what we would be giving her for credit, or added to what we'd be giving her for credit for her earnings. Now, what would be, how else would we be adjusting the amount of the child support order? Marissa? In this case,
Other than the child
other
care?
than the child care, is there any other adjustment that would be made?
Don't think so.
No, but in some cases, would there be?
Possibly.
What else? What would Mr. Patina get a credit for?
Health insurance.
Health
He's paying it,
insurance.
but
If
it's
he's
not-
paying health insurance, now he isn't. Our guy is not paying health insurance. But if he were, say he were paying $100 a week towards family health insurance, what would happen to his child support obligation? Jason?
50%.
It would be reduced by 50% of what he would be paying for family health coverage. So it would be reduced by how much if you were paying $100 a week?
So $50 a week.
He'd get $50 off the total child support bill as a result of the fact that he's actually
covering the family's health insurance, all right? So the final figure was, yeah,
I have one question about the form, just even getting to, it's a silly question, but is yearly salary, there's a formula you can use to say get a monthly salary and then a weekly by using 4.3 instead of dividing the total year by 50.
oh, okay, so slight variation
Slight
of what you
variation.
get.
Does the court, is there ever any quibbles over that? Like
No, not
if
really.
you choose one way as opposed to the other?
Not really. I would do the divide by 12, frankly, if that would be easy. When you knew, if you know what he was making, not divide by 12. If you knew what he was making annually, I would do the divide by 52 thing.
But the usually have pay stubs to work with, which are
But if,
monthly or.
right, if the pay stub you have to work with is a bi-weekly one, that's easy, right? And a lot of people do get paid bi-weekly now. If it's a monthly one, then you're just gonna do it 4.3. So, work with what, as you say, work with the pay stub, but if you know that, it's an annual kind of thing, that's, 52. Do that too. Yeah.
I get a little confused on this, and I'm looking at part 3D, which is the custodial adjusted gross. And I came up with the number, and I'm not sure.
Okay, again, in this particular case, you're not gonna have anything, because.
Oh, it would be zero?
Because
Okay.
she didn't make the $20,000 to begin with,
Oh, so
right?
it's only.
She made $14,000 for the year, and you can stick your figures in there, but there should be a zero there, because she isn't, you're not gonna show a negative amount there. She just, there's no adjusted anything to have to really do here. All right. Final figure, Regina? $433.40. That's what I got. Your financial statement. This probably was your first attempt at doing a financial statement, one way or another. I will email you a sample that I did, so that you can see how it's worked out. The main thing with these, of course, are the monthly figures, converting a monthly rental and a monthly gas figure or whatever, electric figure to a weekly one. You divide by 4.3, okay? You count everything, every line has a zero on it or a number, okay? You don't leave anything blank, otherwise what might the judge think?
Just for me to clarify, so it's 4.3 and not 52, correct?
Well,
Or it's
4.3 of the figure you know is a monthly figure. So in other words, you pay your rent by the month. And your rent is $700 a month. Well, you're gonna just divide that by 4.3. If, however, let me just say that there are some bills that fluctuate so much depending on, your heat bill, your heating bill. It's gonna fluctuate so much from month to month that you might wanna take a 12-month average of what you actually spent and add up what your yearly cost is and divide that by 52. If that's accurate and you can back it up, that's okay, that's a valid figure. The idea though is that you don't just make them up, you don't just pull it in out of the air. You have some backup for it and some way to be able to rationalize how that figure got on that line.
How do you vet it out? You get all the bills from the client? Most of the clients probably.
Well, most of the time you will ask the client to collect it and average out, the bills. So I don't normally, most people, collect their telephone bills and their things, but I ask them to collect them and make sure they have them together and that they have backup, and then I want to see them write out for me what it is that they've paid, Yeah.
Well, it's kind of related. I mean, sometimes there's just no way to substantiate it, and people may not actually know what it is. Can you estimate it?
Exactly. And that happens most often with food and incidentals and things like that, where, there might be several trips to the grocery store in a week, and it might be just done with cash, $16 today, $20 tomorrow, a couple days later, $40, whatever. however people do it. Some people go to the market once a week, and that's what they have for the week, and other people don't do it that way. So that's one of those figures that is going to be a little bit mushier, and you're going to have to say, you know, can you stand behind that figure? You know, is that what you spend? What do you spend?
The other question I have, I think, is they have a check account, bank account with $5,000 in it. It doesn't show any interest income whatsoever. It's probably minimal interest, but is the court going to say, hey, where is the interest?
Yeah, no, I would have to say that, you know, if it's a minimal kind of thing like that, you know, for most of the people that I think, you know, most of us are going to see, you know, interest income over the course of a year might be, you know, $5.17 over the course of a year. And this is asking for a weekly income figure. So, I mean, it's really an irrelevance at some level. One thing is that you will be required to report on the bottom of page 1, your yearly income for the prior year. So if that turns out to be higher than if you annualize the figure that you see on 2L, right? 2L is total gross weekly income. So if I were to annualize that and find out that it's a lot lower than what I put on, you know, line 7, I'm going to ask a question. What happened? What happened to, did you lose your job? You know, is business bad? Maybe it does, you know, maybe what isn't accounted for might be something like you say, interest, dividends, things like that. And that's where you're going to pick it up and be able to question, you know, the veracity of the opposing parties or your own client's financial statement and say, well, you must be missing something. You know, you're working for the same employer, you're doing the same things, you know, is there other sources of income that you haven't reported? So.
How important are the 1099s?
Very important. You have to attach them to the financial statement. Very important. You have to attach them to the financial statement. Paula?
I was on Holly Bettina's side to do this.
Yep.
Now, I know when accounts are joint and whatnot, they both have to list them. What about Mr. Bettina's stock options and pension? Does that have to go on her?
Yeah, that'll have to, if you were, and I didn't ask you to do his financial statement, right? I said do a financial statement for her.
I put it down, but I didn't know if I had to.
Yeah, no, I didn't, yes, you would put that. That'd have to be listed as an asset. And you might not, where would you put that?
That's where I did put it.
Financial institutions, plans, other.
I
Other,
think he
you
opened
put it under other, where it says such as stocks, bonds, collections. If you don't have room on the financial statement also, you add sheet. You say, you know, and see attached. Or rather than even filling that in, you'll fill in the total and say, please see itemization attached. And on your attached paper, you'll have your caption, your case caption, docket number, and refer to item number, whatever it is, assets, other assets, and list the, you know, whether he has stock options, what the value is, etc. And there's a special formula on those depending on a grant date and all the rest of it. So a lot of these things, and as well as the bonds, a lot of those things you really can just do right online. You can get the calculations for those things now online. You can ask them for the series, you know, numbers, etc., and go right to the bond calculator, and that'll tell you what the bond, each individual bond is worth. You can pretty much do the same thing with the stock options. You know, you can get a history on it once you know where to go for this particular stock, how to value it, and you know, there's information as well online on how to do it. So those actually are relatively easy. The more difficult ones will be the, you know, the not so definite annuity and, you know, that kind of things. Those
So
pensions.
everybody's listing all marital assets though. Both sides are listing all marital assets.
Well, you know what?
Like the truck and the car.
If they're both in, you're listing all of the assets that your name is on. okay, or that you have a beneficial interest in, say as a trust beneficiary or something like that, okay? I would not, for instance, have my client, if he were Mr. Patina, put on his financial statement the cash value of her life insurance policy, okay?
Yeah.
That's hers.
Right.
And if the stock options are in his name only, they're gonna go on his financial statement, not on hers,
Okay.
all right? But if they're joint, they're gonna go on both. You better see it on both, all right? And the other thing is too, some people think they're cute by, you know, having their mother hold their money, or their brother hold their money, or this is in their, you know. That's your money. If it's your money, it's your money. The idea of this is the financial disclosure is it has to be a complete and accurate disclosure of your financial position. What do you need to advise your client about with respect to doing these financial statements, Jason?
Well, there's an automatic kind of, I don't know, sort of injunction that happens to keep things in the status quo once something is filed, but also just being honest about and accepting the fact that if you have joint property, it's joint and it's not to be taken all away.
That's one thing, okay, that's one thing, and I'll talk to you a minute again about, I don't know if I didn't already, but the automatic restraining order under Rule 411, you all saw it when you looked at the summons. Defendant gets served with this restraining order when he gets served with the summons, or when she gets served with the summons. I say he here because Mr. Patina was the defendant in this case. They all get served with the summons. And with the summons comes an automatic restraining order. It's little if you look at it on the summons, but if you were to print it right off, you know, it's fairly lengthy. And basically, you need to look at it. But basically it says, everything you two have right now, you're gonna keep. Nobody gives away anything. Nobody transfers, sells, mortgages, transfers, anything that they own right now without the permission of the other party, the written permission of the other party, without a court order. All right? Everything stays, status quo, assets are frozen. Okay? I have a case right now where I have a guy that wants to sell a car. He wants to sell his car. He wants to just buy a bike. He needs her permission to do it. And then she wants an accounting for when he sells the car, either she wants the money that he makes, if he makes more money than the car is worth, either she wants the money in an escrow account, or she wants them, they need to have an agreement on what's to be done with the profit. So, I mean, it does get that, we might be talking about only $1,000 here, you know, which basically he could just put in the bank and keep paying to her as child support or something, but, you know, it was an asset and it's gonna retain that character, and we're gonna have some agreement as to what happens to it. Yep.
I'm sorry to make you repeat yourself, but I just want to be sure, because I'm not clear on it. So Mr. Patina's pension plan and stock savings plan through his work, Holly Patina's still supposed to put that on her financial?
Did I say that?
You did,
No.
but you said only if it's a joint, if there's if she's a beneficiary or.
Oh, no, I'm sorry, no. That won't be on Holly's.
It will just be on his.
That will just be on his, exactly,
Okay.
I'm sorry. That will just be on his.
Okay.
Just like the stock options would just be on his if they were in
Okay.
his name. It's his retirement.
Right.
It's not a
Okay,
joint
so it's hers.
retirement, it's
Okay.
his retirement, all right? So it's gonna go in his financial statement, and she's probably gonna show nothing on hers. And that's the way it should be, that's how the judge needs to see it, that she has nothing and he has one, all right? Okay?
Like the cars though, I mean, there's two cars.
Yep.
You know, one belongs to her, one belongs to him, but in all likelihood, they're both in one person's name.
Well, that's the question you have to ask your client, is, you know, how is title held? How is title held? And that's how you have to list it on your financial statement. You know, even if it's, you could say, you know, title is joint, but it's in his possession. I would say that. Title joint, but in husband's possession. Yep.
Also, does it happen that one party might not know of the assets even if they are joint? So then do you have to do a
modified statement later on? I mean, what is?
Well, I mean, you know, there's an exchange of the financial statement, so at that point, there's gotta be an opportunity to be able to look at it and go, where did this account come from? And there'll be an exchange, you know, that kind of thing doesn't.
Like,
And yeah, you could amend your financial statement in the future to make it accurate. You want it accurate. Sometimes people do innocently forget to put something on the financial statement. It's something they haven't used, they don't think about, you know, they have only so many days to do it sometimes, and they really just innocently forget. You know, it's not necessarily a matter of misrepresentation. It just, you might be in court and they might go, oh, I forgot to put whatever. So, you know, if that's the case, you want to add it in, but, you know, if it happens after the fact, then you know, you just say, you know, this is what happened, send it in writing, this is the disclosure. You know, we'll formally update it the next time we update the financial statement, but you put it in writing and you let the other party know that, you know, so they know that you're being forthcoming. It's not a matter of you trying to hide something. The other thing I was going to say when you said about the restraining order, you know, why do we want this in the form that it's in, is that if financial disclosure is not complete, or it's intended to try to sidestep assets so that you look like you don't have things that you actually have an interest in, your clients need to understand that that could be the basis for overturning a divorce judgment entirely. Fraud and misrepresentation are reasons for the court to vacate a judgment because it was based on a financial statement that contained misrepresentations, material misrepresentations, that had you known the truth, you would not have made the agreement you did, or whatever. The court may not have made the order that it did. Yep.
I wanted to see forensic accountants actually just in court when they did divorce proceeding.
Say that again, I'm sorry.
A forensic accountant to take a look at the flow and see whether if the numbers add up.
It happens.
Does it happen often?
No, well, I mean, it happens only in cases where there's enough assets for them to, for it to be, you know, a big issue. You know, I mean, Mark and I were talking earlier, I mean, Lawrence and Methuen, you know what? It's not gonna happen all that often. You know, most of the people that, you know, we see in and out of court, you know, are struggling to pay the heat. You know, we don't, probably not gonna be worrying about forensic accountants. But, you know, in instances where there are businesses that need to be valued, and one of the parties has been in control, perhaps, of the accounting, the business, the receipts, you know, the deals, whatever, that's probably a valid request, is to, you know, have a forensic accountant take a look at the asset, to value it, and also to see what's coming in, what's gone out, how has this been run? You know, what are the amounts and sources of income actually? So that's what we're really looking at, amounts and sources of income and assets.
The 45 days may not be enough.
And 45 days may not be enough, but you know what? Your client should be able to give a good faith estimate, you know, of their own, and you can say it that way. This is plaintiff's good faith estimate at this time, you know, or, you know, value to be determined by an expert. You know, let the court know this is a work in progress. But if you've got a certain number of days that, you know, for instance, I asked you all to prepare a discovery request as well. When you looked at discovery rules, is there mandatory discovery that has to be made or exchanged? 410. 410. It's supplemental rule 410. There's an entire list of documents that have to be exchanged within 45 days of the time that the defendant was served with the complaint and the summons. So within 45 days, and one of those things also is that the financial statement has to be done during that amount of time as well. You're not just going to be making a complete financial disclosure, but you're going to be giving backup
that's what this is. The things that 410 asks for are federal and state income tax returns for the last 3 years, along with 1099s, W-2s, those kinds of backup things, statements for all bank accounts for the last 3 years, 4 most recent pay stubs, documentation that